our purchase price is whatever the payoff is at the time of closing. We can't put that here, so what I say is see special provisions. We check off loan assumption addendum, and then in paragraph 11, we're going to say purchase price is payoff of the existing loan at time of closing plus X dollars net to seller. If the seller is getting some dollars in addition.
So you don't even, okay, so you put that.
I put nothing in paragraph 3.
Okay.
And if you want to get fancy and put TBD because it's not determined yet, or you haven't gotten that, you do not have an enforceable contract.
Mm-hmm.
If you can't have a word math problem, so you can figure out an exact number, an attorney's going to come in and say, you don't have a contract. And they're right. And we had that happen. We had a TBD written there.
So 3 lines
but we're
empty.
doing subject to.
Click loan assumption.
Yep.
Right?
Yep.
3 top lines empty.
Yep.
No, you have to put C special provisions.
Yeah, on the
paragraph
first
11.
I'm sorry.
That is required.
Yeah.
See special
Is
provisions.
this a pointer too?
Yeah.
You put that there.
Oh, look at you.
Damn.
I'm
Thank
pretty
you.
excited now. We've peaked.
Because,
Okay,
yes,
so-
that's what he's
right.
saying, it's a
Yeah.
math problem. And
Yeah.
now you gotta go to paragraph 11 where it tells you, which is what I just did on 2 contracts and sent to you,
See?
for the cruise.
See special
Good.
provisions, check on that box.
Yep, check.
Or what, depending on the box.
Check, well, you're gonna check loan assumption, because we're on the purchase now.
Okay.
Sub 2.
We're gonna really use this pointer now. We're-
You're on a roll now.
Yeah.
Better with the batteries.
All right, so.
But it sounds like you're paying off the loan, but you're doing a subject.
The purchase price is.
Is the payoff amount.
The
Payoff.
payoff
Okay,
amount
so.
from the bank.
All right, so let's change this then. Purchase price is the payoff amount of the existing loan at time of closing.
Plus.
There's no magic language.
Yeah.
It's just whatever gets across. What we're trying to do is, if we're closing on July 31, what's the payoff on July 31? That's our purchase price. And then if we're getting some dollars to sell
So
it.
they're getting like $2,000 plus
Yeah.
$2,000 net. Okay,
Yeah.
gotcha.
And we're gonna talk about that more in a second, because if we're saying we're paying all closing costs, we gotta have an out, but we'll talk about that here in a second.
Okay.
So on the loan assumption addendum, this is the TREC promulgated form that we're talking about.
Mhm.
There's this and this that are in the, loan assumption addendum. This is when we're acquiring the property.
Yeah.
We don't want anyone checking our credit.
Right.
So we're not gonna have these in ours.
You line them out.
Yeah, actually, you're gonna just email Jessica and she'll send you one that I've already created that hasn't gone. I prefer not to line them out because if you'll go, well, hold on now, why don't I do wanna check. No.
Just take them completely out.
Yeah. There's also some vestiges of when there were assumptions of properties in here. So it talks about this, you payment of X dollars over to the lender for the assumption, and this right here, consent by note holder. We're obviously not gonna get the consent by the note holder, despite idiots that are in front of the legislature talking about how you could just call the bank and get permission for the mortgage wrap if you wanted to. Back when they were trying to make those changes, I was like, I looked at him, I go, are you an idiot? Or just a liar? I mean, you're one of the two. We kind of narrowed down. It was the
I remember
fat,
that.
fat cat lawyer for the mortgage company. And then, like I said, get with us on the form for these. All I've done is just went to a PDF editor, took those things out, took off the TREC stuff because we can't put them in those TREC forms, and then that's your form. It's pretty wild stuff we have going. All right, so now the sale. We're going to go through the contract and more than that on some examples. So if you don't got it, we're still going to talk about it. On the sale, now remember we're doing a seller finance transaction on this sale. It's just a seller finance. We are seller financing this property. Ignore the fact that there's a mortgage there. Ignore the fact that there's an assignment of that mortgage over to you. We'll take care of all that. Y'all are just seller financing a property, okay? So right here, we're gonna have the third party financing addendum is going to be checked off. These are gonna be now filled out because you're gonna have just a normal seller finance transaction. So whatever the amounts are, the amounts are. If you're selling it for $180,000 and they're bringing $30,000 down, that's what goes in there. All right? So it's simple, very simple. Paragraph 11, I still have this right here. This should also be in the assumption contract. when you're acquiring it. I left it out by mistake, but it's just another disclosure that this is a mortgage wrap transaction. There's existing loans not being paid off. I like saying that around 9 times to these people, because invariably about once every 4, 5, 6 months or so, we have someone call and say, I did not know this was a mortgage wrap. And so I had one recently. I wish I could pull the letter up, because it's so much fun writing the letter, because they got an attorney involved. The attorney comes in and starts throwing his or her weight around and says, this was clearly not supposed to be a mortgage wrap. And I extracted, I think it was somewhere like 11 different times that the person said, I understand this is a mortgage wrap. And so I sent that letter out, and that was a couple, 4 weeks ago. I haven't really heard a lot from them lately. It was fun. So I try to put as many disclosures as possible. On the seller finance addendum, so be real careful with this, because this is a document that governs what the terms and conditions of your loan are going to be. All the other stuff that we've been through sort of talks about it, but this right here, we got to have what that note is and what that interest rate is. And if you don't have it figured out yet, then you're not going to have a contract. So need to be hyper technical on getting this part filled out. There's some choices of how these things will be paid. The second one is what we're doing, monthly payments. The first one's a lump sum, not going to be applicable to us. I forget what the third one is. But you have to fill out these right here. I do not calculate your mortgage payments. Now that's a lie. I confirm your calculation. So in here we'll have people who put the PITI, and then I come back and say, well, your promissory note's just going to have the P&I. We're only doing principal and interest. T&I changes, so we don't hard code that into the promissory note. Can I call a timeout? I got my daughter apparently pinging me. It's funny. He goes with whatever people say. He doesn't change anything about anything. So if they want to have PITI payments or P and no I, and it's funny. I said, well, you know, why are you doing that? Why don't you help them along? He said, I'm not going to get myself into any type of liability here. If they want to say that it's $2,000 a month, I'll put $120,000 promissory note at 8%, and $2,000 a month doesn't match, but he still does it. So figure that out. We got a really cool amortization table I've been using for years and years and years. If you want that one, I can send it to you. All it is just some Excel spreadsheet that someone created. I didn't create it, but it's real good for us. So we'll check it, but we're not gonna provide those numbers for y'all just because of liability.
So,
yeah.
do we go ahead and include the PITI or just do the PI?
So,
But then when we actually tell them what the payment is, do we include the PITI?
Yeah.
Okay.
So what I used to draft up a first payment letter for folks, and we don't anymore. And the reason we don't is because they don't give me the information put in there. So we're going to need how much is the T&I,
Right.
and then they say, well, it's the taxes. Just divide that by 12, Alan, or Michelle or Selena, and I say, well, no, because I mean, what do you want to do? Do you want to try to look at last year's taxes, or do you want to try to extrapolate and see what this year's taxes are going to be, or where are you on your taxes? And then the insurance, they say, well, whatever insurance is in place, just divide it by 12. No, you're going to get new insurance in place. We're not going to tell you the T&I. If you give me the PITI and the place where payment's supposed to be made, we'll draft up that first payment letter.
Okay.
Or if you want my form, I can send you my form out too. That's a form that we can send to folks. But however you want to do it, that's the best way to do it, is to have a first payment letter signed at closing, just like a normal closing.
Right.
And all of my documents are designed to simulate an absolute normal closing. What I want is this thing to look as if it's 100% normal, A, because it is, and B, because when someone comes back and says, hey, this was not fair, I can say, here's the documents that are the exact same as Wells Fargo would have been sent in. So I like the first payment letter being the very first document in the booklet that's created for them.
Okay.
So just say, raise your hand and say, give me the form, or here's the information, fill it out,
Okay.
and then we'll do that. This right here has to be filled out. I always require consent I put a do on sale clause. They can't go sell my property without paying me out. Now, would I give my consent? probably would. I might vet the buyer that they're looking at. But like I was arguing with the mortgage companies at that legislature, if I can get 2 people on the hook, that's better. Why am I not gonna have 2 people I can go after? I'm probably fine with it, but I always say you have to get my consent required for that. And then also, I can't fathom a situation where escrow wouldn't be required on a seller finance note. Actually, I guess there was one time. It's usually a non-arm's length transaction. I always require escrow on my seller finance transactions. Yes, ma'am.
So, okay, so you're selling it owner financing, you're getting the PITI, you're having it escrowed, and the property's gonna be deeded to them as the new owner, but if they default and you have to foreclose, then you have to get it back, and I heard of other people not giving them the deed, they're holding the deed until they finish paying off the loan?
So, Wally used to do that. He doesn't anymore. It's extremely dangerous to do that to the buyer's side. If that deed's not recorded, then liens can start tucking in front of them, especially from the, well, I guess the prior seller's already out of it though. So I don't like that. I wouldn't do that. I also don't think it's going to help. In order for me to get someone out of a property via foreclosure, if they want to fight me, they can do the same thing with an eviction. We had an eviction start August of 17, and it just wrapped up July of this year.
Wow.
So I can stop anyone from doing anything for a while, whether it's foreclosure or eviction. So I don't see any advantage to that. I see a disadvantage because it looks like you're taking unfair advantage against the buyer. It's simulating a contract for deed type transaction, which is bad. Those are the bad things they were trying to stop with Chapter 5, the property code on lease purchase options, contract for deeds, and stuff like that.
Mm-hmm.
So I don't like it. Would I do it? I don't know. I'd have to look at maybe how long that note's for, how long it's going to be paid off. I don't know. But I can see people doing that.
Yeah, because I hear of people
I don't
doing
like
that, and as an incentive for them to keep making their payments.
Well, the other incentive is you can foreclose on it.
And I guess in theory foreclosure is potentially.
Because these properties are still, the first loan is still under the other person's name, and technically, you're still involved, even though you sell or finance it to somebody else, you're still the middleman, making sure that the first mortgage is getting paid.
Yeah, so on one of mine, I had a situation where I didn't follow my own advice and the mailings weren't coming to me. So I get a phone call from a really mad seller saying, you know, I'm taking this property back. And I said, hold on, what's going on? And so the escrow increased. And so we were just paying a couple $100 too little at the time. And so I said, you know, you gotta hold the right fella now, just let me fix this, and we just fixed it. So yes, you guys stay involved. And those mailers are not coming to my office.
Do you ever use a third party,
Arm loan?
yeah, loan?
I don't, mainly just because I don't have enough properties. If I did, I probably would get that all managed somewhere else.
Right.
So they're taking the phone calls from people and stuff like that. But
Right,
now,
but you handle it all now, so if they stop making payments, you know instantly.
Yeah.
And then you can start making payments so it doesn't get foreclosed on, and you call them up and say, what's going on?
Yeah.
I'll give you $1,000 if you move out, and you start the whole process over again.
yeah, and we're the absolute nicest lender that's ever been in the world. I don't call these people up and say, I'm a lawyer, I'm gonna get your ass on the street in 4
Right.
days. I say, something's going on.
Right.
Let's talk about it. You know, I'll give you 45 days to get out if you pay me 75% of the mortgage. You know, really, if you just give me a deed in lieu and don't pay me nothing, I'm
Right.
happy.
Right,
So,
you got basically, you might offer them cash for keys, kind of deed it back. And
I start with reduced payment per month to me, and then nothing if you give me the deed in lieu, and then I'll give you $500 if it's clean and you give me that deed in lieu.
Right, Right, so, yeah, you try to make it easy on them, so you don't have to go through a foreclosure process.
Yeah.
The whole bit, and that way.
And I, you know, we've probably had, we've had a substantial number of defaults. When I say we, I'm talking about my clients' closings, not just mine. And, I would say we probably had to go down to the county maybe 3 times. And that's usually because there's an MIA person, the buyer just hauled, or someone just lacks complete honor whatsoever.
Right.
Just trying to stay for free.
You want to stay involved because, I don't know if y'all picked up on what we do here, but we buy houses from people going to foreclosure. We get notice of this one earlier than anybody else.
Right.
Exactly.
So we want to make sure that we stay in touch. The other thing we do in this scenario, we're the bank. We can do a loan mod.
Yeah.
If they've been paying on it for 5 years, and Alan, correct me if I'm wrong, but if they've been paying on it for 5 years, they've paid a lot. They've paid down a little bit of principal, not very much. But if they need a $200 less payment, I'm willing to stretch that to another 30 years. I'm willing to stretch that out as long as it makes sense. So we could do a loan mod and essentially create a new loan. Is that?
Absolutely. Absolutely.
And
Right, and just basically start over with them again.
So basically you just refi it.
yeah,
Right.
you
And
can
then
do a
you
refi.
Yeah,
You can
do a
create
refi,
new terms.
extend it out another 30 years, drop that payment.
Instead of
And-
adding on, like most banks that add on lawyer fees and blah, blah, makes the payment go up, you work with them. Now instead of owing 20 years, they only owe 15 years on your original note, on the original mortgage.
And-
What's the process of doing that if you have to go through that, come back to the track and do another?
No, once you get something hammered out, then we just do a loan modification agreement. It's a couple page document, recorded, and that's all it is.
And another thing to avoid this is, just like we don't want to become motivated buyers, we don't want to, when we have rental properties, we don't want to take the first tenant just because we're desperate. We never want to get in a position that we're desperate. We never want to pick the first owner finance buyer because we're desperate. We want to vet our buyers, and when you vet your buyers much better, then you're much less likely to default. Does that mean they have to have a 700-800 credit score? Absolutely not. But I want to make sure, what I look for in my buyers is I want to make sure they've got a significant down payment.
Yeah.
I want a significant down payment because it's going to hurt to walk away from that mortgage. I want them to walk away from a lot of money.
How do you verify that? You get a snapshot of their bank account, basically like a promissory note?
I get a check. No, well, I mean,
I get a check, yeah.
but I mean, yeah, they have to have a check at closing.
Yeah, he's
Well,
trying to
yeah.
turn it.
That-
But
it
yeah, I mean,
clears.
early, yeah, I mean, I would take a snapshot of a bank account, or I would just say, when you come to closing, if you don't have a cashier's check for $15,000-$20,000, then
We're not-
Yeah,
we're
right,
not-
yeah, I'm not gonna just give it out,
The-
right?
Probably
The-
also kind of proof of funds, because you don't want to tie it up in contract
Yeah.
until then.
yeah, so
That's
you'll
not
want to get some
waste
sort of
of
proof of
time, yeah,
funds.
so-
Yeah,
And the other thing that I want to do is I want my payment, as I'm doing my math, I want my payment to be right underneath market rent. I want to be right underneath market rent because I want them to take a walk out of their house where they're paying a mortgage, and I want them to pay more if they move to any other house on the
That
street.
makes sense.
The other thing is if they get in real trouble, they can rent the house out themselves and let them and still pay their mortgage. I don't want people to walk on my loans. There's unscrupulous investors out there that have a business model of get a down payment foreclosed, get a down payment foreclosed. We don't want to do that. So you can vet you do your homework on the front end, and that makes the relationship a lot better down the road.
So on the lines of payments, do Brent or Alan, there is loan servicing companies, that sounds great. You're saying you don't use one. So instead, what do you do in the scenario where PI payment is $1,200, but this is a hardworking person, they're like, well, no, you know what, I know it's $1,200, I can afford $1,200, but I wanna put an extra $100 a month just to pay this off early. How do you
Apply the
recalculate,
principal.
how do you keep up with that?
So
You have the
I prefer-
spreadsheet.
I prefer not to do that.
Yeah.
But I do have a couple, and so that little spreadsheet I'm talking about, actually you can put additional payments.
There, and
It's a mortgage.
Yeah, escrow specialist is one of the ones that I've used.
There's probably something better than what I use, but I'm able to manipulate however I want. It's just a real
And-
regular Excel spreadsheet, so it's good.
How many times have you run into that?
Not very, we're not dealing with the most financially savvy
Right.
people.
That's what I'm saying.
They're gonna make the bare minimum.
The bare minimum. Yeah.
Because they buy on terms and they're like,
Yeah.
and they usually buy it at the most that they can afford.
But I do have one that rounds up.
Yeah.
It's like 1192.47, and they're like, here's $12. And I'm like, damn.
Yeah. So then you gotta do the work to
Yeah.
figure out,
But
because in the end, they could come back on you.
No, you can have an Excel sheet. I forgot, cause I did a
Yeah.
loan that I had to keep track of.
Yeah.
And I made the Excel sheet with all the multiplications and all that good stuff. Yeah, I can do that.
I'll make sure that everybody here has my personal Dropbox. Everybody that signed up, I'll send you my Dropbox. I have an amortization table in there
Oh, that'd be great.
that has a spot for additional payments.
Thank you, Brent.
Now, going back on the, what I was talking about, courts don't wanna kick people out of the property. So they're gonna err on the side of the tenant buyer in those situations. They also don't want to take people's equity away. And so, when I have people come to me, whether they close at my office or otherwise, and they say that this person's behind, my first question is how much equity is in there? And if there's substantial equity in there, then I put the brakes on and say, we're gonna handle this a little bit differently. And I would suspect some people probably think that I'm just scared to go to court and start tossing people out of their houses. Not scared. I'm not a nice attorney if you're on the other side of the table from me. I'm only nice on my side, but the reason it looks like I'm being nice to them is because if you don't give them every chance, then they're gonna be able to stop you in the courts.
Yeah.
And so I had this one person, got the deed in lieu because they were late, and then they continued to be late, and so the day came that they were supposed to give a lump sum payment, and they didn't. So I called and I said, hey, you didn't do your lump sum payment. Said, well, I FedExed it, and they sent evidence of the FedEx, which doesn't necessarily mean they
But that
sent the
check
payment.
is in it.
Yeah, and my client said, file the deed in lieu. And I said, I don't want to. And so she made me file the deed in lieu, and then I think they spent somewhere around 10 months in litigation. I don't know how many thousands and thousands of dollars. Because the check came the next day, she went and lawyered up, and then lawyers can invent any reason to sue anyone for anything, and they did. So you just have to get to be ultra nice. If there's a bunch of equity, let them sell it. I had a situation where a guy said, all right, well, I'll let you sell it, but it can't be forever. You've got 60 days to sell this thing. Give me a deed in lieu, and we'll hold off for 60 days. You gotta get creative like that. You don't wanna start taking properties back, unless you have to. I mean, you know what the court is.
Well, and again, too, that we door knock to help people prevent foreclosure, so we really don't want to be that person saying you're going to foreclosure either.
Yeah.
Right?
Just a side note, some of the people that I know that do make a habit of doing this, they advance it to county or something. I don't know what the technical term is, but they skip the jurisdiction. They just go straight to county, and that way they can, because I guess
On the evictions?
yeah, and I don't know what it's called, but they
JP court, they skip
yeah,
JP
they skip
court.
all that and they just advance it.
You know, I wonder what they're doing is since appeal of an eviction is you don't appeal that decision. You're starting a whole new trial. So what they're probably doing is skipping that, since they know all they have to do to appeal is
Yeah.
pay $500 bond or what have you, and they're up there and you're starting all over. So they're reducing the process if they're anticipating these people appealing.
Yeah, but in county, I guess they're having more luck of being able, no matter the equity or anything, just based upon the contracts and the law at the time. So, I don't know if you've.
Well, and that's an eviction process versus foreclosure. I've been on the stopping foreclosure side. I guess, yeah, I'm gonna say a lot more than foreclosure, but yeah, a lot more than foreclosing. And I've never been unsuccessful in stopping a foreclosure, ever. And that was even when the judge one time, this is real fun, I like when my clients are secretive. sitting there before the judge, and she starts clicking on her computer. I'm trying to get a temporary restraining order, and she goes, "This is the 5th one that your client's filed." So I feel like she's going, "Well, that sucks, Judge. I'm out of here." And so we still got that temporary restraining order. Now she had to pay, I think it was somewhere in the neighborhood of like $13,000 as a bond, because that's how much she was behind. But we still got it, and I was amazed. They're just rubber stamping them. And I understand, you don't want to kick anyone out of their house, but geez Louise, after 5 times, I think my client should have been kicked out of their house.
Yeah.
So the people that were asking yesterday, how do you be on the foreclosure list 22 times?
22 times.
Is that right?
Yes, when I have access to the Houston foreclosure to go, and so we start targeting just 0 or 1 or 2 prior posts. So when I'm going through to vet these people who to go knock on, 22 times is the most I've seen so far. I've had 17, 10.
Their calendaring system is really messed up, because all they're doing is just waiting until the foreclosure comes, and then they pay. And wait until the foreclosure comes, and then pay. They need a better tickler.
It's
Yeah.
yeah, when I'm seeing 22 times, I go, how does that happen?
Maybe they're keeping the money in a high interest rate, or maybe.
No, they're doing is they're probably loaning their money out at 12%.
That's the only way it makes sense. It's like, you know, I don't want to get a big fat return check from the IRS at the end of the year. I want to keep that money myself so it can earn more money for me.
It's called infinite baking.
Yeah, so they're just holding their money, loaning it out or
It's
something. That's the only way it makes sense to reinstate it time and time again.
It amazed me when I seen it. I'm going, what the?
That's
I feel like this conversation is about to go towards one of the conversations I had with Walter Walford of how do we create a pre-probate list?
Oh, yeah.
I have gotten a citation from HIPAA.
Senior living assistance.
Any
questions?
Yeah, what are the mechanics on the escrow? Do you leave it on the underlying loan, do you then reflect it through to the new loan, do you start a new one and clear the first one?
So the escrows are exactly the same. T&I owed over to Wells Fargo, is T&I owed to me.
Okay, so you're just reflecting it from one to the other.
Because Monzingo sent my insurance, or sent their insurance up there, and so we're tracking the same numbers.
Now, are you requiring the buyer to do the insurance to Monzingo as well?
Yeah.
Okay.
Oh, yeah. You don't understand, if someone doesn't want to use Monzingo and they're closing in my office, I have them sign a document that says, we understand this is going to fail because we're not using Mike Monzingo to get insurance in place.
Right.
But even the buyer of the owner finance.
Absolutely. I wouldn't give them an option ever.
So you just tell them that insurance is already in place.
I give them a document that says, here's your problem.
It's okay. It's not an earthquake.
You're not in California.
So, I'm sorry,
I just give them the information and say, here, you need to call Mike and get insurance set up.
Oh, okay.
There's just no option.
Right, and then.
And actually, that broker assists me too. That broker's keeping in contact with that end buyer, and so I usually have a little conversation with them.
Right, and they don't know what they're doing, so they always think.
Do any of the end buyers ever complain about that, want to shop their insurance around or anything?
I don't care.
Yeah.
I tell them if you do find insurance that's cheaper, it's because it's not the correct insurance. And that's what I'm parroting what Mike told me.
People don't pay attention on insurance regardless.
I do.
Until there's a, yes.
Well,
Regular people
You're a
do
normal
not.
rational person that pays your mortgage.
Yeah.
Yes, I am.
Well, and one thing to be careful of also when we're doing these is that we have to stay on top of the.
In a second, there'll be a break, and we're going to kind of transition over to a different area. We'll go until then.
Yeah.
Yeah.
Everyone will leave at 4 o'clock, whether you're done or not.
Yeah.
And
I learned that yesterday.
I know where the pool and the bar are. So,
Yeah, I was gonna say the bar.
don't throw me in the briar patch. So real quick,
Yeah.
Oh, that
we,
was.
that's the family pool.
You remember.
I'm not going in the
A lot
family
of this
pool.
is supposed to stay in the.
yeah, we'll skip some slides. So I'm not going to go into a lot, but we kind of talked about it. We're using all the normal loan documents for just any normal loan. some will try to get by with just having a deed on the purchase side of this thing. Dear God, don't do that. Or if you do want to do that, just give my business card and we'll talk in a little while. It looks like you're taking advantage of the seller. You're not getting all the right protection documents in place. You don't have disclosure documents in place. Seller can't go out and get a new loan by utilizing the promissory note. So on a subject to, you can get by without these documents for different reasons, but you don't want to.
So.
We go
so
back, I didn't
No.
So I just want to ask a question that I get asked a lot. So your bottom line says if you don't do this properly, the seller cannot get a new loan without a promissory note to show property sold. So one of the biggest, I don't get this objection from sellers, but I get it a lot. I get this objection from a lot of big dogs when I explain buying a property subject to. But the seller, if we're taking the property subject to, can take the promissory note to their new lender and say someone else is paying this?
Yep. They want the promissory note. They want evidence of payment. I don't think they wanted the deed of trust. There's a third document, the deed. I don't know why they would want that, but at least those two things. And then they're treating it as if it's just a rental. So sometimes they'll give you 50% credit on that payment. Sometimes up to 100% on that payment, so that seller can get a new note once they get cleaned up.
So they can?
We don't like going to the same lender.
So do we coach them to not go to the same lender?
Left hand doesn't know what right hand's doing in that stuff, but I just don't like it. It's
In case they cross let's say meet at the watering hole.
Yeah.
Water things by chance.
And in theory they're refined, so they shouldn't care anyway. Maybe they can't refi. I don't know. I don't like it. But
So in theory, they can take the new promissory note to the new bank, and what else? What other documents?
So if they want to go buy a new house, their loan to value or credit to debt to income ratios are going to be all out of whack. Average person can't go and buy $200,000 houses, but you're going to take that promissory note and evidence of payment, and then that new lender for that seller's new house is going to say, okay.
What do you mean by evidence of payment?
That someone else is actually paying their mortgage.
They have to show that payments have been made timely. So you could get, I guess, an account history from the lender. You get actual payment, copies of checks that were issued, whatever that new lender wants.
Usually it's online. You can just print it because you've got the
Transaction
access,
history.
and you just do a history.
Give it to them on their behalf, okay.
Yeah.
Right,
Okay.
so that's where they need to come back to you, because you've got everything over their account. Right, they're on.
They can always regain access.
Yes.
We had a
Yeah, they still have the
Yeah.
password unless I change it.
Well, they just call in and give proof of.
they call in.
Yeah.
We had a disgruntled seller. The buyer out, buyer would send their authorization in, and the seller would kick them back out again. Another reason we want to keep our sellers happy. So yeah, they still have control. Okay. So here's where I was saying we could take a break if you wanted to, but we're gonna go through some contract examples. We've kind of already talked about it, so this may be a little bit moot now, but this is an assumption of no funds to seller. So you got $120,000, seller to receive 0, buyer paying all closing costs. On completing the contract, we're gonna do, like we said, see paragraph 11, purchase price is payoff, buyer to pay all closing costs. Now that right there is something that's absolutely common on these subject twos, but it causes me some concern. And so what I like to do is have an option period, allowing me to withdraw if something comes up, a HUD loan that they didn't know about,
The Medicare loans.
Medicare loans, is a Medicare loan a closing cost? No is the legal answer, but do buyers or do sellers understand that? You said you're gonna pay everything that was needed to close. You have to pay this Medicare loan or any other thing that pops up. So I like my option period to be.
Or maybe put a cap not to exceed $3,000.
I'm taking a parachute. I'm able to get out of that for any reason I want to.
If a HUD loan comes up during lien, but the number still makes sense to take over, then you do it subject to does the HUD require payoff at closing, or do they just,
So
what happens?
We wrap those HUD loans, and when I first did it years ago, I was like, well, this isn't good, because it says if you sell the property, you have to pay this HUD loan, and we're selling the property. I know for an absolute fact the definition of what we're doing is selling that property, and so I was concerned, but apparently HUD is just as stupid as Wells Fargo, and
Okay,
they
because,
don't know anything.
because what we're seeing at the one in Waco is the sellers really don't understand what's going on at all. But they said, we owe up 165, well, we looked up on their, with Penny Mac, it says they owe 125. So
So they're including the HUD loan?
Either there's a HUD loan or they're just wrong and not knowing how much they actually owe on the house. So,
So we've had a situation where that was occurring, and we're like, we don't understand what's going on here, and the second lien wasn't being pulled up. And so we had to go back to them and say, hey, why are y'all saying you owe this? Well, did you get the second? So title can miss that stuff. That's kind of what title insurance is for. If it's not recorded in the magical way it's supposed to be recorded, then it may not get picked up on a search. And that's what happened. So we actually had to send the second loan documents to the title search plant and say, you need to include this. They were able to track it down from that. So those situations can occur too.
I'm getting a little more worried now. Because
It
the
happens.
title company that, like I said, working with, I don't know if they're gonna catch that.
Just get title insurance or?
Title
Sale of
insurance,
property.
title insurance will take care of that.
Okay, okay.
And we're gonna talk about title insurance. Should we get it or should we not?
So I have a question. So I have a lien on a deal. Lady's 92 years old. She's a ward of the state. She's in a nursing home. The nursing home has put a lien on the house. Her trustee or her guardian, state attorney, won't talk to us about, they've officially abandoned the house, her ownership, but she's still on the deed.
Okay.
But it has this nursing home lien on the property. So how do we work around that or work through that?
So did they get a judgment? And then is a judgment lien against it? Because
I don't know how they did it, but they're recorded as one of the
maybe it was
liens.
a judgment. So it needs to be paid at closing. Otherwise, you're taking it. I don't think you want to assume that. And then you're going to say seller's not getting enough money to pay it, right? So then you need
Or maybe do it as a, I don't know. Take it over subject to that it's not gonna get paid off until we sell it on the back end.
We've done that. We close like that all the time. For some reason, apparently people want to keep their money. I don't know why.
I know, it's
And
funny.
so-
Well, she's she's dementia, she doesn't even know where she is, and,
Yeah.
I mean, she's a ward of the state, she has no
So-
heirs, no nothing.
So someone's appointed to act on their behalf, and that person won't talk to you?
Exactly, because they've abandoned it, and they don't wanna reclaim ownership in order to sign the documents
Can't they
with
just
us.
put it in a trust and then now it's not, it's a personal property, it's not actual, it's,
They could, but they don't wanna touch it, they don't wanna do the work.
Yeah, they're not, apparently they're not, but it reminds me of one of the episodes of The Office where Michael comes in and goes, I declare bankruptcy.
oh yeah.
That's not the way that works.
That's not the way it
You
is.
can't just, there's no legal abandoning of a house. They should sign off on a special warranty deed or something, selling that property to you. Because who's gonna sign?
It would have to be that guardian,
Yeah.
that state attorney.
I think
Well,
they should
we
just
can
put it
talk
in
more
trust and
offline,
sell the
but-
trust, it's easier.
Have them put it in a trust?
Yeah, put it in a trust, then
But
there's,
who's gonna pay for that work?
it's $25.
Oh, you're talking about, on the purchase?
Yeah,
Oh,
then you just sell off the trust and there's no,
but you still have the issue of who's signing off and.
I need to buy it from
nursing.
somebody, I need to have somebody sign the contract.
And they're not gonna put it in a trust.
yeah.
And they won't let me talk to her, I can't go to the nursing home, they won't give me access to her.
Who's like, your people, stop talking to them. Yeah, tell them to stop. Yeah, I mean, unless the whole lawyer to lawyer. phone call.
Hire Alan to be the new guardian. Kick the old guardian out. You got a new guardian now.
Yeah, that's,
And the county won't talk to me because she has back taxes, and I called the county directly. Hey, I wanna buy it from you, I'll pay the back taxes and get everything current. Oh no, we can't talk to you because it's deeded to her, she's a ward of the state, you have to wait till she dies before we'll even talk to you.
we'll see if we can call the attorney.
Okay.
Okay, I think that's it. Oh, and then you're using the loan assumption addendum on that. All right, so, the next one's not too exciting. This is the same thing, except seller's gonna receive 3,000. So the only thing that changes is our paragraph 11 information. We're still getting our option period, and that's the loan assumption addendum. So the contracting on the sales side of these things, on what I call a wrap. So payoff is 120, purchase price is 210, down payment is 20,000. Now, on these paragraphs, the 120 is ignored. That's not part of our deal. Paragraph 3A is 20,000 down. Paragraph 3B is a $190,000 note. Paragraph 3C is an addition, 210,000. That payoff doesn't come into play on the contracting side of things. On figuring out, all your math on it, sure, but ignore it in your contracting. I get people who are trying to come and they'll have really what essentially is a assumption and seller finance transaction where they have a $120,000 assumption and then $80,000, or was it $70,000 seller finance note. And I don't like that for a ton of reasons. Well, I don't want to go into the reasons, but this is cleaner and cheaper. The other way, you're going to pay more money to get it drafted up. If you have a situation where you're trying to mimic a payment, then do that. So let's say our payment on the 120,000 is $900, and we agree that we're going to pay them just an extra $600 a month. Well, then reverse engineer your numbers from that to get to your interest rate and loan amount and whatever you need to get to that price specific item. So I've reverse engineered that amortization table that I'm talking about, got down to 6.1275862 interest rate, so it's exactly the right number, as opposed to creating two different documents. We went fast on that, it was kind of clunky, but bottom line, we don't want to ever do an assumption and then seller finance at the same time. That's just a wrap. Yeah? And then we're using the seller finance addendum. Here, this is kind of an item I like to put. Earnest money is still not required. If y'all do want earnest money, maybe release it to the seller or something of that nature. If it's $10 especially. Is everyone still like using the $10 earnest money? Why do we like that?
I don't use the earnest money at all.
He said no. Alan says no.
I usually put $100.
It's de minimis.
Yeah.
It causes clogging issues sometimes when you have to get that released or what have you. But I always remind people, earnest money is not required. If anyone does tell you it is required, give them my information. I'll talk with them, ask them what the statute is they're relying upon, and they'll be educated. And I have 15,999,000 other people in Texas to educate. Now, alternatively, you must have an option fee. Please don't ever take what I say about earnest money not being needed and extrapolate that over to the option. You gotta have option dollars in there to have an option agreement. If you don't have dollars in there and you say I've got an option for 30 days, you don't have an option agreement. That's what we're talking about. Do I need title insurance? The attorney says yes, because it's the most careful way to do things. The title company owner says yes, because that's how we make money. The lender says, yeah, you're gonna get it. And the real answer is, it depends. So we'll go off here. I've said you have to have a title insurance on this, and that's the way it has to be. Now, this is other discussion we're having that doesn't involve me. You're gonna do a risk-benefit analysis. If you're assuming a property and you're paying $3,000 for closing costs or what have you, why are you gonna go over there and pay a couple, $3 grand for a title policy to protect that $3,000? You don't need it. The risk there is fast forward 15 years, some kind of title defect is discovered, which that's not the way they happen. It happens in the first year or so that these things usually occur. You got a bunch of equity in this thing, well now you're not protected. That's pretty dang remote. So you gotta look at how much money you're putting in to the thing, and evaluate the risk. If there's deceased parties, liens and judgments, it's been a long period since the last policy, whatever other factors that increase your risk, then that goes into the equation to decide if you want that title insurance or not. Questions?
So you're saying that it's, as an investor, it wouldn't be necessary, because again, the two houses that I have, sub 2, the seller's not getting anything. I'm literally just paying closing costs. So
If it's clean.
Yeah.
they bought it, lived in it, moved away briefly, came back, bought another house, and then moved to Austin. And now they're selling their two houses in clean.
So scour the Schedule C and make sure there's nothing on there.
Other than the underlying mortgage.
Yeah, I'd take a look at Schedule A where it has the seller's name and make sure that's jiving with who we're contracting with. And if that's true, then it's kind of like Best Buy. You know, if I buy a computer for $750, I'm not buying a $200 warranty. So, but I said a person who's going to do this, I'm getting title insurance every time. And all of y'all are too. No, I mean, to be honest with you, I don't. I look at the Schedule C, and if it's clean, I'll close the assumption without title insurance. Now, I'm also going to be able to fix anything that comes up for free. So I've got that.
Have you read, just out of curiosity, the title attorney, have you read this and are pretty good at picking out liens? You have some experience finding liens?
I've learned a couple things doing this for,
I mean, I'm not real good at finding liens, so I mean, I'm gonna buy it either way, because I feel like I'm a lot more likely to miss something than you are.
This is Phil. Shanoa's absolutely the other way. Doesn't care what she's spending, she's getting title insurance. And you know, my pop is the same way. He just wants it to be easy. So he's gonna spend a little bit extra money, do everything the exact right way, and that when a problem comes up, he goes, not my deal, I paid for this already.
And also to think about it, if you're getting like Longhorn Investments, Jeremiah is an attorney, and so usually you get a 6-month or a 1-year term on your hard money, and now you're kind of protected on that side. So when you go to refinance it, you're buying it out from yourself, doing the burst strategy, and then when you're closing, you already know from that first year nothing's come up. It's pretty clean title. So
in my situation where there might be a HUD and it's discovered after closing,
you're getting title insurance all day long in McLennan County.
Yeah.
On that deal.
And they asked me, it's like, you want, I don't even think they asked it, it's like, yeah, we want title.
You want 2.
Yeah.
I'll take 2
Right.
title insurances.
Right, so, but if something comes, because we're gonna have to pay like $14,000 to reinstate the stuff, and if it comes back, you know, after closing that there is a HUD, what?
That's covering your 14,000, you're protecting your 14,000.
Yeah, if there's anything hinky on this thing, you know, we just now had a affidavit of heirship come back, and it was a little bit fuzzy. Nothing popped up that was wrong, and I forget exactly what it was that caused me to, after I was looking back at it, I saw something. But it turns out that 2 of the siblings accidentally forgot there were 4 other siblings.
It happens.
And so, dude goes by to look at his new property, and someone's mowing the yard, and he goes, what are you doing? This is my house. And he goes, well, I'm working for the owner. He goes, well, I'm the owner. He goes, no, the owner's in Florida. And so then it all kicked up. And so now, I mean, the property's on lockdown, but that guy had title insurance. So if anything fuzzy's coming up, then you get title insurance.
And then what happens if there is, then I get my 14,000 back, and then the house goes back to the original seller?
Yeah, so you're only protected up to the owner policy amount.
Right.
So, $120,000 or what have you, whatever you bought it for.
Right.
There could be a situation where, you know, your lender is $110,000, and now you've had to carry that thing for X period of time, and you've spent $20,000. Well, you you could be 10,000 out of pocket if things go the absolute worst. You need to compare your lender policy, your owner policy, I guess. But yeah, you're gonna be covered on your 14.
Right, okay.
And because the lenders, the only time a lender's gonna be paid off is, we did have a situation where, a daughter came out of the woodwork from overseas somewhere and she wanted the property back. So the lender had to be paid their money, and then the investor got what was left over, and he was short a few dollars.
The lender actually repaid him?
The title insurance.
Oh, the title insurance.
Yeah, title insurance paid lender.
Oh.
And so they didn't know about the daughter? That's why she suddenly showed up and she wants the house and that's why?
That one actually was straight up fraud.
Oh, okay.
The